Hello and welcome to Ascot Lloyd and Freeths' first live joint webinar event, and thank you for joining us today. My name is David Malloy and I'm your host. Today we want to help answer some of your questions around being an executor and how we can help you prepare. Before we start, a few formalities. So today is live, and we've done that so we can take questions. So we're going to do a Q&A at the end of the event to take any questions that you might have. So please feel free to write the questions in the Q&A box, which is at the bottom of the screen. And as I say, we'll take them at the end. You can also answer them or ask questions anonymously as well if you like. We'll be sending out the answers as well via an email for all attendees after the event. So any questions that we don't get to answer today, we will answer and we'll send those out with a follow-up from today's event. You'll also be able to watch back the video as well. So today's being recorded. So if there's anything you miss or you want to share with family and friends, again, there'll be a link on the email which will allow you to watch it again if you want to. There is a bit of audience participation, so we will require you to press a few buttons today if you want to, and that's just a free polls during the panel's discussion today. So we're going to ask you a couple of questions, and there's an ABC kind of answer, and that will help us understand our guests today. Little bit about Freeths and Ascot Lloyd. So Freeths is a top 50 law firm, has 13 offices spread across the UK and has over 200 partners and directors. Their family wealth practice is ranked as one of the top legal practices in the UK for wills, trusts, tax, probate and corporate protection advice. They advise private individuals as well as business owners on a range of contentious and non-contentious wealth preservation matters ranging from value of £500,000 right up to over 200 million. Ascot Lloyd, we are one of the UK's fastest growing national independent advisory firms. We have a regional and local presence across the UK and have more than 130 fully employed independent financial advisors. We also look after over 8 billion of our clients' wealth. We hope you can find the next 45 minutes informative. Becoming an executor or indeed deciding on who should look after your wealth is such an important thing, and it's often a decision that is made through a short informal conversation over a meal or a few drinks with family and friends. But there's a lot to consider to ensure that the right things are in place to fulfill your wishes. Indeed, it can be the time when legal complexities come to the fore and the need to make important decisions as well when family emotions can also be running high. So today's hopefully going to give you a bit of some food for thought around that. There are three specialists on today's panel who will be holding the discussion. So I'm going to introduce those. So I'll start with Mark. Mark Rodgers is an independent financial advisor at Ascot Lloyd. Mark began in financial services a little over 25 years ago, so has seen most market and regulatory events during that time. Mark joined Ascot Lloyd as an independent financial advisor about 5 years ago. Mark has advised both corporate clients during his time along with personal individuals and their families. Mark's areas of expertise include investment planning, retirement advice, both pre and post-tax matters such as inheritance tax, and ensuring individuals and their families are protected against unforeseen life events. Sally Goodger is a director in Freeths' Wills, Trust and Inheritance Tax Disputes team. Based in Oxford, Sally acts for individuals who are executors, beneficiaries, trustees, attorneys, administrators and court-appointed deputies, dealing with a wide variety of contested matters, including executive disputes, will validity claims, inheritance tax claims, trust disputes and mental capacity issues. And finally, Charlotte. Charlotte Digby is the director at Freeths' Trust, Estate and Tax Team. Charlotte specialises in the preparation of wills for high net worth individuals and deals with complex estate administration matters. Charlotte is a member of the Society of Trust and Estate Practitioners and has achieved accreditation in advanced will preparation. So they're your panel for today. We'll start off with a fairly straightforward question. I'm going to ask this one to Sally. So Sally, why is it important that people make arrangements for their assets following their death, and why should they give full consideration when choosing the right executor for the job?
Okay, morning everybody. Thank you, David. Yeah, I mean, documenting your testamentary intentions in a will during lifetime means that upon your death, your assets will pass to your chosen beneficiaries, subject of course to any claims against your estate or will validity challenges. An important part of preparing your will and getting your affairs in order is choosing the right executor. As you'll hear this morning, getting this right should mean that your estate will be dealt with as smoothly and as cost effectively as possible when the time comes. We all want to avoid a situation where your hard-earned money is spent on lawyers sorting out issues which could have been avoided had you sought the right advice as to your will and financial affairs during lifetime. Now, bearing that in mind, if someone is appointed an executor, Charlotte, what are the different options that they have for acting?
Yeah, good morning, everybody. Thanks, Sally. So it is, not many people know, but if you're appointed as an executor in a will, you don't actually have to take up your role in the estate administration. There are different options available to you. So you have one option that's called power reserved, and that's really a postponement of an executor's right to obtain probate and deal with the estate administration. So it might be that you have an executor that doesn't want to completely relinquish their entitlement to administer the estate, but at this moment in time they may not be able to take up the role fully, so they can then take up the role at a much later date and apply to the court for the grant of probate if they need to step in and if they want to step in. If you have an executor who simply doesn't want to act in the estate administration, then they can do what's called renunciation, and then they relinquish completely their right to act in the estate administration, but they can't do that if they've already undertaken some tasks in that estate administration, so selling assets or paying off some debts at the beginning. And then you might just have an executor who wants to take up their appointment. They've been appointed in the will and they want to crack on and get on with the estate administration. So it would be useful actually, Sally, if you could tell us a bit more about what the situations are perhaps where you can't act as an executor, or some reasons why you may not want to take up that role.
Yeah, of course. Thank you, Charlotte. Yeah, so first of all, an executor needs to have the capacity to act. So they can't be a minor, they need to be 18, they need to have mental capacity, they can't be bankrupt or insolvent, and they can't be in prison. So those would preclude someone from acting as an executor. As well as being able to act as an executor needs to be willing to act. So there are a number of reasons why an executor may choose not to take office. For example, they may be ill. They may consider the appointment too time consuming. They may have work or business commitments that means they can't commit the time that's required to the administration to get the job done in a reasonable time. It might be impractical for them to act, for example, if they live overseas. An executor may have doubts as to the validity of the will. And this may mean that they don't want to be involved. Also, they may have concerns as to whether the estate has sufficient funds to pay for everything. Again, a reason why an executor might not want to take office. A further reason why someone may not take office as an executor is if there are disputes. So, for example, if you've got family members appointed as executors, if there are already disputes between them and the beneficiaries or between the executors themselves, or they anticipate such conflicts arising, then they may think it more sensible not to take office. It's important to remember that if you are an executor, you must act promptly, impartially, and in agreement. So as an executor, you can't act unilaterally. Another thing to bear in mind is if there's a situation where someone may have a claim under the 1975 Act whereby they want to seek provision from an estate, you could be an executor who would like to claim provision, and that would put you in a conflict situation from taking up office. Another thing to bear in mind is in a situation where executors don't take any steps, but they haven't done anything themselves to relinquish the office of being an executor. There are a number of procedures that can be used to try and appoint new executors in their place before they've taken out the grants. Of course, an executor might be quite happy to get on with the job of being appointed the executor, and of course they're free to do so, subject to what I've just said. Now, I've got a question for Mark, actually, that I think sits here nicely. Mark, how do you believe a client's professional experts should come together to assist executors in their duties?
Morning, everybody. Thank you, Sally. I think it's really important that professionals work together, especially at this particular time You know, I'm a strong believer in pooling together, I think, both experience and knowledge, and using that expertise to provide a better outcome, obviously for the client, but more importantly at this stage, for the executor. I know I often work with solicitors and accountants when dealing with the deceased estate, and I think all the combination of knowledge and experience, it reduces the margin for error on behalf of the executor, and I think hopefully it provides a better overall client experience. So I think it's really a time when professionals work together.
Excellent. Thank you for that, Mark. We're going to do our first poll question now. And what we'll do is, if I can just get the poll question up. So these are fairly straightforward. So how much thought have you given to choosing your executor? And you can see if you could tick one of the boxes and then put a cross on close the thing down, and then we'll come back to that. Just while you're doing that, I'll just do a quick recap on some of the points that we've just discussed. So who should be your executor? Age and health should be taken into account. And why shouldn't people act? My personal situation, I have an identical twin brother. He lives in Australia. Now, when I first set my will up, he was my executor. We both have young families at the time, and I obviously knew that his views and you know, he'd have my interests regarding my children at heart. Now, we're both very competitive. I absolutely expect to outlive my brother. So having him as an executor now, as we get older, is probably not the best person. So again, things can change with your wills and how you decide who your executor should be. And I think the other point was co-executors and professionals supporting those executors. I think that was a really interesting point made by Mark there, as well as Sally, I think. You know, who is involved and how that works is quite crucial to how these things are dealt with. Okay, let's look at the results of the poll. So thank you if you've managed to complete that for us. So we have a bit and a lot, it's almost a dead heat. So that's quite interesting. I think it's nice to see that the people have given obviously some thought to what they've done, but again, it is one of those things I think I alluded to at the very beginning. You know, people are asked, and the polite answer is obviously yes, and you feel flattered, but it's actually taken into account, and I think that's a good point for us to move on to the next question, actually, which is, I'll open this one up to Charlotte, actually. Charlotte, in terms of the duties, so tell me a little bit more about the duties and risks of acting as an executor if you decided to take up that role.
Yes, so the position of executor actually carries with it quite serious responsibility to administer the deceased estate correctly. And failure by an executor to carry out their duties can give rise to personal liability. So that's one, the liability paid by you, the executor, personally, rather than out of the estate assets. So it's quite a serious undertaking, and the duties are very wide-ranging. So they can range from locating a copy of the will, registering the death at the beginning, arranging the funeral, contacting everybody you know, who would like to come to the funeral. And then you move on through the estate administration. It's important to follow your duties to value the assets of the estate, and also to make sure you're aware of all the liabilities of the estate, because you can be personally liable if you haven't located all the creditors that need paying from the deceased's assets. And then also there's obviously quite a big duty, which is reporting to HM Revenue and Customs. So making sure you've reported everything correctly for inheritance tax, but also dealing with the other taxes that do crop up in the estate administration period, which is capital gains tax and income tax. And those duties are very serious ones with HM Revenue and Customs. And then obviously, as you move through towards the end of your estate administration, making sure that you are distributing the estate in accordance with the deceased will, or the rules of intestacy if there isn't a will, and locating all the beneficiaries and legatees that are named in the will as well. That's quite an important one. And making sure that everything is paid up and all the assets are dealt with. So the duties are extremely onerous, and the risks personally can be quite serious, especially if you're dealing with quite a tricky estate administration. So Sally, it would be good to bring you in here, because it would be interesting to hear if you've dealt with any cases where executors perhaps haven't adhered to their duties and stuck to the rules, and how that plays out?
Yes, thank you, Charlotte. Good question. I mean, it's right. Executors fall out with each other. They need to agree on instructions, like I've already alluded to. They need to be able to give solicitors their instructions. And there are ways that can be taken to remove them and deal with them. But in terms of cases that I've dealt with recently, I had one not too long ago where I acted for an executor. He was a sole executor. He was administering the estate of a late aunt. He wasn't a beneficiary, as other family members were. And he collected in the assets. I think he sold the house and had cash. And he took it upon himself to invest the cash in pens. So he spent tens of thousands of pounds on pens, and his plan was to resell the pens at a profit. Now, what he had misunderstood was that it is not his duty as an executor to enhance or improve the value of the estate assets. His duties extend simply to collecting in the estate assets, paying the liabilities and distributing. The executor in this case was at great risk of losing money for the estate, because pens, I'm not sure how they hold their value and how they resell. But you know, any difference between what he'd spent on them and what he made when selling them was his personal liability. So that was a real risky strategy for him, and not one that we would have recommended had he mentioned it to us before he started buying pens. So it's hard to forget that one. Another case where I dealt with a couple of years ago, I acted for 3 executors with a dispute against their 4th executor. It was a homemade will. There was a dispute as to the interpretation of the terms of the will. It being homemade made it very difficult to interpret. So unfortunately the testator hadn't helped matters, and probably would have been wise to go and get some professional legal advice when preparing a will. Nevertheless, we had a 3-day trial whereby the court had to decide how the will was interpreted and whether the 4th executor got the legacy that was in the will. And so, as I said, if the testator had taken the right advice, both from a legal and financial perspective, rather than doing a homemade will, I'm pretty sure a 3-day trial, which comes with quite a lot of costs, time and stress, could well have been avoided. Just thinking again, Charlotte, I want to bring you in here. How can you avoid these potential difficulties at the outset during the will making process?
Yeah, I guess just to quickly say, if we've got a pen specialist on, please do get in touch with Sally and I. We'd love to hear further from you. So how can you avoid ending up in Bristol with Sally at a trial? So I think Sally touched on it, which is go and see a solicitor, have your will professionally drawn up. People sometimes worry a lot about the cost of doing that, but often firms will offer, fixed fees as we do, and it's not actually as costly as you might think, and it will save you and your estate a lot of costs in the long run. How to think about choosing your executors. So you might want to think about the family dynamics that are already in play. So you might have 2 people who you're thinking would be good candidates for being executors, but perhaps there is already a bit of a dispute between them, or they don't get on so well. They're probably not going to be ideal people to appoint together, because executors do need to act together and they do need to get on and agree to avoid it ending up in court or, in dispute with one another. And also to think about the characteristics of people you're considering. So you might have somebody who you think would be a good candidate for executor, but they're perhaps not very financially astute, or they are not very good with administrative tasks. So you might want to think about whether they're good candidates to appoint in your will. And keeping it under regular review. So executors' lives change as well as yours. So if they've got big life changes happening, they may not be, in a good place to deal with the estate administration, giving consideration for all the duties and the risks that comes with it. But if you would like to have friends or relatives in there, you can also consider appointing alongside them a professional executor. So that could be a financial advisor, an accountant, or a lawyer, and they could just sit alongside them, helping them with those, difficult sort of complex tax situations that might arise, and that might just be a good something to think about.
Excellent. Thank you for that, Charlotte. We're going to do another poll question now. So this is poll 2, so 2 of 3. And it comes back to really what we've talked about over the last panelist questions and what have you. So when did you last review your will? And you can see there's 4 different options there. Again, while you're looking at that, I'll just kind of summarise my take on the questions that we've got there. The type of skills an executor might need. Again, I've been an executor myself. I know that I was chosen because of my background in finance. So I was able to do that side of things. The other executor in my situation was somebody who had emotional connections, that had known the person for a very, very long time. So I was there to kind of do the moral side of things. So I think that's quite important in terms of the skills that somebody might need. Personal liability of an executor, I think that's a really valid point, and a lot of people will obviously go into this probably with their heart in the right place, some perhaps slightly more nefariously, but there is liability there. So again, that's something that people need to be fully aware of if they go into these kind of things. And I think it's always great. The example of the case study is a fantastic way of kind of highlighting. I'm sure that all our panelists could give you a number of different scenarios and times when they've come across cases which have been quite odd or have had different situations. So let's look at the results to the poll. So again, very mixed. So when did you last review your will? So most haven't, or are kind of, well, 5 years I guess is fairly high as well. But again, that's interesting, and again, it highlights, I guess, why we're talking today about the importance of kind of reviewing your will. So, so thank you very much for completing that. Come on to another question now. This one's for you, Sally. What do you do if it's too late and you have an executor in place who isn't dealing with the estate in the way they should be?
Okay, thanks, David. Yeah, I mean, if you've got an executor in place, they've taken out the grant of probate, there are ways to remove an executor. Now, you can remove an executor by consent, so everybody agrees that it's the right thing to do. You need to find a new executor who's willing to take up the post. That might be a lay executor or a professional executor, as Charlotte said, a lawyer, an accountant, a financial advisor. You might want to appoint an independent administrator. It really depends on the circumstances. And if you can't agree, no agreement can be reached, then you can apply to court to remove an executor. It's quite a high bar to remove an executor, so it's not a task that's undertaken lightly. It can be expensive, it can be time consuming, it can be quite stressful. But there is a procedure whereby the court can remove an executor. It's completely within the court's discretion as to whether they do remove an executor and appoint a new one. And the welfare of the beneficiaries of the estate will be of paramount importance to the court in making that decision. The court also do bear in mind the fact that the testator chose the executors. So there's got to be a pretty good reason why they're no longer suitable to be in office. And of course, costs, as I've touched upon, they can be quite expensive. Again, they're in the discretion of the court. They may well come out of the estate monies. There are situations, however, where an executor, if they behave so unreasonably, they may be personally liable for the costs. So there's a lot to think about, and each case is different and turns on its own facts. But thinking about how for a question for executors really, Mark, and this one's for you. How important is it for executors to understand the underlying investments of an estate prior to taking any actions?
I think it's absolutely vital, Sally, that executors fully understand not just the responsibilities that you've been talking about, but obviously the risks attached to it as well. So I would like to say that my clients would have a really sound understanding of how their particular investment or pension products work. That can't be said necessarily for the executor. The executor might be, with the best will in the world, might be, financially less aware. Their own personal situation means that they might not have come across investments and complexities in the past. I think when we talk about cashing things in and encashment generally, we'd be very, very careful not to incur a liability to the estate. You mentioned before about capital gains tax, about inheritance tax, making certain that ISA wrappers might not lose their tax-free status. So I think there's a real education piece where an executor needs, you know, to fully understand what they're actually dealing with before they create a potential tax burden. I think we've covered quite a lot of ground there, and I'd like to ask a question for Charlotte, really, just to kind of summarise, and that would be, when making a will, what are the general top tips we'd recommend people to follow?
Yeah, so I obviously get asked this one quite a lot, and I've touched on it already, reviewing your will regularly. So we recommend every 3 to 5 years, or when perhaps you've had quite a big life change. So if you've got married, that can in fact revoke your existing will. So it's a good idea if you're considering getting married, or have got married and haven't thought about your will, to get in touch with the solicitor to talk it through. Also, if you're having children, you'll also need to consider obviously what you'd like to leave them, but also guardianship appointments if your children are under the age of 18. If you've had a recent bereavement in the family and you're perhaps going to be receiving some money into your own estate, that's a really good time to review your will, and also go and see your financial advisor, because obviously that's going to have an effect on your own estate planning, and you may need to make a few changes to your existing will. And also if there are changes in tax legislation, so who knows what the future will hold for inheritance tax, but obviously over the last few years we've had the introduction of the residence nil rate band, and that's a really, if you haven't reviewed your will post residence nil rate band, it would be a really good idea to do so, to make sure that you know your will is the most tax efficient it can be. Making a really good accurate record of your assets and liabilities and lodging that with your will and your financial advisor, and keeping it up to date all the time as things change, because that's only going to obviously get you the right advice from both your solicitor and an IFA, but also it's going to help your executors know what's there, what they've got to value when you've passed away. And also finally, just keeping a really accurate record of any lifetime gifts that you're giving away, because obviously your executors have to report lifetime gifts to HM Revenue and Customs, and actually the reporting that they have to do is quite detailed. So as much as you can put down, like dates, how much you've given, what type of thing you've given away, so cash or property, keeping that all with your financial advisor and also with your will is going to be really, really beneficial in the long run. If I could just throw it back to you though, how do you interact with executors, you know, during your meetings with clients, and also what do you think the benefits are to interacting with executors? Is there a benefit you see for their estates in any individuals?
I think there's a real benefit for the individuals, and I think it's a real benefit for the executor. And I think it's something that we're all becoming far more aware of now, and the need is not just to ask, have you got a will, and who are the executors, but I think it's really would be best practice in my role to actually meet with the executors, and ideally around the same time. I think the will was either reviewed or the first time the will was made. I think for me, establishing a professional relationship with the executor, you know, helps them make the right decisions in the long run. I think where we've not been able to meet the executors, at least me being able to forward simple information such as email addresses, contact numbers. I think they're particularly important, where we start to create that all-round trusted relationship. And as we're demonstrating hopefully this morning, I think with client agreement, I will start to be recommending that executors dial into these remote meetings. You know, I hold an annual review with every client. That what's to stop the executors dialing in as well, and you know, for them to enhance their knowledge and awareness. So I think it's a really important thing to do, and an action that I want to take forward, Charlotte.
Thank you, Mark. So we're going to do the final poll question now, and again I'll summarise. So how many of our guests today have introduced their financial advisor to their beneficiaries or executors? That's really come off the back of the comments Mark's just made, really. Also, just to highlight the key points slide, so I think the key things for me were the top tips. I think that was really important. You know, the importance of regular reviews on the will. Excuse me. The importance of your executor knowing about your assets and investments. Again, that comes back to my experience as an executor, where you're rummaging around looking for share certificates and trying to find, because you want to make certain that you've not missed anything. It might be premium bonds, it might be something that you're not even aware of. Now, that for the person who's having to do that can be quite hard to do, especially at a time where the heightened emotions, as we mentioned earlier. So having that stuff together is quite important, I think. And involving trusted advisors at an early stage. You might think, well, you would say that, wouldn't you, from an advisor or a legal perspective, but it does make a big difference. And from our experience, looking after clients where it's not happened or where it's gone wrong, it can be either a significant additional cost to unwind or to rectify things, but just having that sense check even in some cases. So let's have a look at the results on that one. So that's quite a high one. So in that case, so most people haven't introduced their executors to their financial advisor, and again, that's not uncommon, but it is something, and that's one of the reasons for instigating today's conversations, is to kind of highlight that and ask whether that is something that people feel you know, they should be thinking about or considering. So what we're going to do now, we're going to come on to some of the questions. So thank you for those of you who've asked questions during the panel discussion today. So I'm going to read some of the questions out. Let me start with one for Sally, I think. Sally, the question here is, what should executors do if the beneficiaries are in dispute?
All right, good one. Thank you, David. That's a good question. The executor's role is to remain neutral, okay? So they stay in office, they leave the beneficiaries to resolve the dispute between themselves. They might be asked by the beneficiaries in dispute to provide some information, often about the value of assets within the estate and other questions, and there's a duty to assist by providing information and documentation. But in terms of the dispute, they should remain neutral and wait for the dispute to be resolved before administering the estate. What an executor must do, however, is preserve the estate assets. So there are certain steps that would need to be taken, even if there's a dispute going on in the background, to ensure that the estate assets are preserved until the dispute is resolved and they know how the estate will be distributed, whether that's under the terms of the will or any other agreement reached.
Okay, thank you for that. One here for you, Mark, I think. What documents should I keep with my will? So again, I think that's referring to financial documents there.
It's a good question. I think not enough people keep anything attached other than the will. So from my perspective, I think the most valuable thing a client could leave would be a copy of their financial fact find, a really comprehensive document that we use when giving advice. And it pretty much includes everything, all sources of a client's income, all of their assets and policies, pensions in payment. All of this information is really going to speed up and promote the efficiency for the executor. So definitely a copy of the financial fact find, perhaps a copy of the last financial, the valuation report. Again, it's going to give the executors a rough idea as to what's out there and the valuations, and perhaps flag up whether there's a potential inheritance tax liability already. Obviously, any trust deeds where investments have been placed into trust, life policies, etc. I think I mentioned this before, perhaps a business card, just so you've got emails and contact addresses. I think they're really important, and I think based on the content we've got earlier on, perhaps keep a pen there as well.
Absolutely. Thank you, Mark. One for Charlotte, I think. Can I have, how many executors am I allowed, or how many can I have?
So interestingly, only 4 executors can prove your will and act in the estate administration at any one time. So I would recommend appointing between 2 and 4, maximum of 4. If you do have obviously lots of people, then you do get a too many cooks in the kitchen situation. You've got to juggle a lot more personalities, and people might not always agree.
Mm-hmm.
But if you just have one executor, sometimes that can always present problems, especially if, you know, they pass away. That's an added complexity, and they pass away when they haven't actually finished administering your estate. So I would say between 2 and 4 is quite a happy place to be. It's, you know, the right amount of people.
Excellent. Thank you very much. Another one. So I'm going to read this one out. It's quite a long question, but I'm the executor for a friend who has a fairly large amount of money, and I'm worried about the fact that they will have to pay death duties before I can obtain probate. He is currently in a nursing home and suffers from dementia, and I have power of attorney, and I've registered this with most of the financial institutions where he has money. Would it be an idea to open a joint account with another person who has the power of attorney and put the money in that to cover his death duties? Who wants to pick that one up?
Yeah, so I think I'll probably take that one. So that's a really interesting question. Obviously, every different situation is fact specific, but it is a question that pops up a lot, because to be able to deal with the assets of the estate, you need to have usually your grant of probate. But before getting your grant of probate, you need to have paid your first instalment of inheritance tax to HMRC. So you end up going around in this sort of circle, because you can't, without selling assets, you haven't got the money to pay HMRC usually. So there are a number of different things that executors can think about. One is something called direct payment scheme, and HMRC will actually, if the executors apply to banks and building societies, they will actually pre-grant of probate send funds to HM Revenue and Customs to pay the first instalment of inheritance tax. You also can consider, perhaps, I've dealt with high net worth families who might already have liquid funds that they're willing to loan into the estate that they'll get back once the money is available. And also you can look into executor loan providers and things. So there are a number of options for executors to think about. If you've explored every avenue and you can't get access to funds to pay HMRC for the inheritance tax, then in certain circumstances you can apply to HM Revenue and Customs, listing all of the avenues you've explored, and ask them to waive the first instalment deadline for tax payment until you've been able to sell the assets. But they will only do that in very extreme circumstances, and that could result in you having, you know, HMRC putting a charge perhaps over a property that's in the estate, so they definitely get paid at a later date.
Okay, thank you for that. Another question that's come through, how do executors best deal with house valuation? So if a house is under probate, who would the executor appoint to value the house? An estate agent would surely up the value of it, whereas the executor would need to be wary of the tax to be paid according to the value of the house.
Yeah, I think that might be me again.
Right.
So if you've got tax in point, so if you've got inheritance tax liability for your estate, I would always recommend that you get a chartered surveyor's report and to value the property at the date of death. And they'll be RICS certified, and they will do a complete belt and braces report of your property. They'll identify any structural difficulties with it that might affect the value. They'll also identify any planning, development opportunities. Estate agents will provide you with 3 market appraisals at the date of death, and you could use those if you haven't got inheritance tax in point in your estate. However, if you've got inheritance tax, I think the chartered surveyor's valuation is the best way to go.
Excellent, thank you. Another question for the panel. When my friend was very ill in hospital in Spain, his daughter asked if I could go and visit, as she thought that her dad had said that he had made me an executor to his will. How do I find out if in fact I am an executor to his will? Who wants to take that one?
I can take it, or Sally, you take it.
I'll do it if you like, Charlotte. That's fine. That's a good question. That, I mean, what you need to bear in mind is that a will is a confidential document. Okay, so it's confidential until death, and then of course the executors, by find out about it and look at the contents of it. It doesn't become a public document until a grant of probate has been obtained at the District Probate Registry. Often an executor would disclose a copy of the will prior to the grant, often to beneficiaries, for example, or someone that may have a claim against the estate, but there's actually no way of finding out pre-death whether you are an executor. And I think it's always worth bearing in mind that people can change their will whenever they like. So you may think that you're an executor, and that may well be the case, but that might not be the case by the time that person passes away.
Okay, thank you very much. Mark, here's one for you, I think. See how you get on with this one. So, is there an amount when lifetime gifts should start to be kept? So, when we're talking about gifting, that was a question from one of our audience. So, is there an amount when lifetime gifts should start to be kept?
Excuse me. It depends, I think, on the frequency and the amount of a gift. Whether that gift's a capital gift, whether that gift is a gift out of income, which I think we've covered off earlier on. I mean, my general view, it depends. Again, have we got an estate that's close to inheritance tax? Is it in inheritance tax? Will it never be in inheritance tax? So a lot of variables there, David. I think my general view on that subject with any form of gift is it would do no harm to record every gift at outset, just in case of circumstantial change.
Excellent. Thank you, Mark. Another question, can executors claim expenses? And if so, what is deemed as reasonable?
I think, yes, that's one for me. So yes, they can get their executor expenses back. So say a common example would be if you go and pay to get your death certificates and you pay £12 and you can claim that back from the estate, absolutely. Mileage, often it's done on the 45p a mile, HMRC approved mileage costs. Obviously, people's definitions of reasonable differ. So you know, I've had a case before where an executor thought it was entirely reasonable to hire out a yacht for the day and claim that back off the estate because the deceased loved boating, whether it's sailing. But that, in the eyes of the estate, beneficiaries, probably wasn't going to be a reasonable executor expense. So you have to think, as an executor, your duty is to preserve the assets of the estate, and is what you're claiming reasonable? Because the people you're going to be answerable to are the beneficiaries, and they're going to want to see a full account of everything that's come out of the estate. And if that's a yacht hire, I'm not sure you can get that one through. Unless you're the sole beneficiary, and then
absolutely. So we've got probably time for two more questions before we summarise. Should organisations such as banks be checking that an executor has capacity to act, or is that the executor's duty?
That's a really interesting question, because there has been a lot of, since the pandemic, there's been a lot of press actually about banks and how they're dealing with estates and dealing with executors. Because in some cases, I think they made higher the amount that they would release to people, executors dealing with estates, which didn't go down so well. I think they have they will want to ID executors, I would say, if you're not doing it through a solicitor. And they will want to see, obviously, a death certificate. If you're going into a bank with your ID and you've not got capacity, it does fall onto the person at the bank there to recognise that. So there is this sort of danger with banks. They're not doing enough checks, perhaps in all cases. So you do have to be quite careful. I would say, you know, as family members, if you know that an executor has been appointed and they haven't got capacity, seek advice from a solicitor, because there are different options available. You can have attorney grants where someone acts on behalf of that person who's lost capacity, but it's a real difficulty. I don't think there's a sort of a set answer to that, unless, Sally, Mark, you've got a set answer to what banks are doing.
No, I think You're right, Charlotte. It's very difficult, and puts quite a lot of onus on the bank themselves, because they're, I guess, not trained to spot somebody that hasn't got capacity. So it's very difficult. And I think, largely if there are family members that are aware, like you say, I think they should be the ones taking steps sort of sooner rather than later if they've got concerns.
Yeah,
I'd agree with your comments there, Sally, entirely. I think really the responsibility is down to the family rather than expect a third-party institution to make that decision.
Okay, fantastic. Right, final question, I think. So if you are married or cohabiting, would it be usual to appoint the person you are living with as executor, or is it okay to appoint a sibling or other member of the wider family?
I'm happy to take that one. An executor can be whoever you choose the executor to be, who you think is the most appropriate person. It would be absolutely fine to appoint your spouse or the person that you live with. Equally, it would be fine to appoint a sibling or somebody else. Some people have very specific reasons for choosing specific people, and like Charlotte touched on earlier, you may want to appoint a spouse or a friend or another relative, but you may want to do that alongside a professional executor. So they've got, it's a sort of two-pronged approach really, and often it can work out quite well. But really there's no hard and fast rule of who is the most appropriate. I think each situation is different, and it's for you to decide yourself really who you think would do the best job and who would be willing to do it, because it's a big ask of some people.
Excellent, excellent. Thank you, Sally. So thank you, panelists, first of all, before we summarise. That was excellent, really enjoyed that. Hopefully today you found it informative and useful. I think it's shown the importance of having a plan, that it's regularly reviewed, and that it's up to date. We will be sending out an email after today's event with the video link of which is the recorded, so you can see the recorded webinar. If you want to share it, with no problem at all with you sharing it with family and friends. So keep an eye out for that in your inbox. The email will also include a link to some feedback on today's webinar. We would love it if you would just take 2 minutes to complete the feedback. It's really important for us to know whether you thought today was right, and it helps us improve webinars going forward. So if you wouldn't mind giving us feedback, that would be fantastic. If you'd like to talk to somebody about making a will, appointing an executor, or are interested in taking financial advice, then again, please reach out to us. We're more than happy to answer your questions. The email being sent out will include details of how to get in touch. So feel free to do that if you want to. So once again, thank you for joining us today, and thank you for your time, and enjoy the rest of your day. Thanks very much.